This is Duke University.
Well, thanks everybody for coming. We want to introduce to you today Duncan Maysilles. He's a Duke Law grad and is going to talk to us a bit about the history of the copper smoke litigation that he wrote a book about, Ducktown Smoke. You have the little highlight up there. So I want to give you a bit of a brief background about Mr. Maysilles himself and hit a couple of things that I think are worthy of note in the book. Mr. Maysilles graduated from Duke in 1979. He did his undergraduate work at the University of North Carolina at Chapel Hill, right down the road, and went on to have a very successful legal career before returning to school to get a PhD in history from the University of Georgia. He currently works as an attorney in the tort and litigation practice of King & Spalding law firm in Atlanta, Georgia, and has written this book, which was published just in the last few months. And while he was at University of Georgia, he was the recipient of an award for distinguished scholarship and distinguished historical scholarship. And very near and dear to my heart, he's also an old-time and bluegrass musician, playing the claw-hammered banjo, the hammered dulcimer, and mandolin. He's been married for quite a long time, an inspiration to me as I'm celebrating my 16th wedding anniversary, and has 5 children and 4 grandchildren. So important, I would think, for law students to know that there is life outside of the law that can be very rewarding and stimulating as much as your own legal practice and writing career. So this book I found very interesting, and I'm so happy that I've had the opportunity to read it and learn more about this area of law and legal history. And it seems to me that it has profound relevance and resonance for many of the environmental issues that we grapple with today. And as you read through this book, you can see the importance of the interrelationships between science and politics and law. You see the age-old discussion where people think that there are trade-offs that have to be made between environmental protection and economic engines. And you see the influence of politics, not only in the decision whether to litigate, but also in legislative decisions to perhaps undo or limit the impact of successful litigation down the road. So I think it's a great book for law students and newly minted attorneys alike for all of these reasons, as well as showing the power of narrative and telling your legal story. So thank you very much for joining us today.
Thank you. Well, folks, it's a real treat to be back at Duke after being gone for so long. And there's a tremendous temptation on my part to reminisce, but I won't bore you doing that on your time. But I will remember one person, and that's Bertel Sparks, my property professor and torts and trust and estates professor. He was an extremely formal man, always came to class dressed as if he was going to be appearing before an appellate court. He was cordial outside of class and very supportive of students, but like many a law professor, he came down hard on students who were not prepared when doing their recitation. What he would do if a student bumbled a presentation on a case, he would take off his glasses and hold them at the end of his fingers like that, look down the length of his arm and say, "You, sir, do not know any more law than a billy goat." I won't tell you whether or not he gave me that treatment, but I hope you don't have any reason to compare me to a billy goat when this hour is over. What I want to do is to discuss 2 key questions. One is, how did the Ducktown area end up being one of the South's greatest environmental disasters? And second, how did a case that was started by 10 humble mountaineer farmers with no economic clout whatsoever devolve into the first U.S. Supreme Court air pollution case and a foundational decision that you find in every environmental law textbook. Not to mention the fact that that 100-year-old decision was key to the standing issues in the recent case of Massachusetts versus EPA. So you go 100 years from the first air pollution case in the Supreme Court to the first global warming case in the Supreme Court. And it started with 10 farmers who started their cases before the Spanish-American War and almost a decade before the Wright brothers flew their first airplane. That's the historical context we're dealing with. To get to the first question of how did this end up becoming the South's worst one of the South's worst environmental disasters, we need to pay attention to the physical setting. That's what's peculiar about environmental law. If you're doing a tax case, I guess it doesn't make much difference where you're doing it as long as you're talking about income tax. But environmental law is tied to the ground, or tied to the resources you're dealing with. To get oriented, this is right here is Georgia, this is Tennessee, and a little bit of North Carolina, and the common corner to all three states happens to be right in the Ducktown Basin, which is here. Here you have the Great Tennessee Valley, but the key thing to note about this, and that's why I had the relief map brought here, is that this area is smack in the middle of the mountains. It's at the foot of the southern Appalachians, the great chain of mountains that goes all the way to Maine. Back then, this was a huge factor in the course of events because transportation in the mountains was miserable. The roads were few, poorly maintained. In fact, in the first decade of this past century, when the first person in Ducktown bought his first car in Atlanta, it took him 5 days to get that car from Atlanta to Ducktown. Well, wind back the clock even further, we have a situation where all this was Cherokee territory, tribal land, until 1838 with the Cherokee removal. You recall in Worcester v. Georgia that the Cherokees won their case affirming tribal jurisdiction, and then the state of Georgia promptly ignored it because gold was discovered in Dahlonega, and that led to the Cherokee removal. The land was all allotted by Tennessee and Georgia in lotteries to private citizens, a key fact that'll come up later on in the case. But even then, this area was a backwater. It was a backwater for the Cherokees. It was a backwater for the early pioneers. In fact, when that land went to a lottery, this was penny and acre land. They had a graduated lottery, and this was the least desirable because it was so hard to get to. There's a gigantic escarpment right here on the eastern edge of the Tennessee Valley that blocked access from the Tennessee Valley and, more importantly, the railroad that went through it, because there seemed to be only two ways to get up there. One was the gorge for the Ocoee River, and then the gorge for the Hiwassee River, and neither one of them were passable for the longest time. When copper was discovered in this area in the late 1840s, and when the mining industry began in the early 1850s, the first thing they had to do was blast a road. They dynamited a road through the Ocoee Gorge, which is now Highway 64, so they could get to the railroad in Cleveland, Tennessee. That's what made the industry viable. But with all those mountains surrounding, you've got the Unicoi Mountains here, the Cohutta Mountains here, and then the Blue Ridge arcing around there. And of course, everything up here is mountains. There's the Great Smoky right there. The two great consequences for our story were this: transportation and fuel. They wanted badly to get a railroad there as early as the 1850s, but the cost of building a railroad through the mountains was prohibitive. And the technology, frankly, was somewhat stunted too. So there was no railroad into that area until 1890. The entire industry ran on animal power. There was an endless trail of wagons going up and down the Copper Road through the Ocoee Gorge on a 40-mile trip each way. The second thing was fuel. Mining is a fuel-intensive business because you have to smelt the rock to get the desired ore out of it. And the fuel they had, without the railroad, they couldn't get to the abundant deposits of coal in the southern mountains. Instead, they relied on local forests. 50 square miles of timber were cut down in the Ducktown Basin. Some of it went to mine construction and building construction, but the vast bulk of it was turned into charcoal. There were charcoal burners that would get the wood, cut it into lengths, cover it up in mud huts so that they burned at very low rate and then turn it into charcoal. And that's what ran the industry. That's what kept the fires going in the furnaces to smelt the ore. So wood exhaustion was one key factor of what happened at Ducktown. The other was the nature of the ore. They came there for the copper. The easy deposits were on top. That's what got the industry going. And when they exhausted that, they dug down into the copper pyrites. And this ore was about 3–4% copper, maybe a little higher in the earlier days, but significantly it was 25% sulfur. And when they processed the ore, the sulfur was considered a waste product. How did they process the ore? Let's look. We'll get some visuals up here. In the 1850s, we got a lithograph of Tennessee copper mine. Oh, it's a pretty one there. Maybe it's the kind of thing a modern corporation would want to put out about their current operations. That was on a stock shareholders communication. Here we have roasting sheds. The way they processed the ore was to crush it, and then they would pile it on top of logs, and they'd set the whole business on fire. All that smoke coming out of there is sulfur dioxide. Those roofs over the piles are because the piles were meant to burn for 3 or 4 months, and the rain kept the roofs kept the rain off of it, so they didn't have the fires dampened, and more importantly, that the rain wouldn't be allowed to leach the copper ore out of the deposits there. So if you can imagine hundreds and hundreds and hundreds of these open roast heaps, sending all of this sulfur dioxide straight into the atmosphere. That's what was going on. And so the combination of overlogging to sustain the industry and the impact of massive amounts of sulfur dioxide trapped in this mountain basin ended up producing scenes like this. This is an evidence photo that was tendered to the Supreme Court for the 1907 decision of Georgia versus Tennessee Copper Company. Doesn't look like much, but the fact of the matter is you can't see anything because of all the smoke. And significantly, there's the Tennessee Copper Company complex right there. Here's the Ocoee River, and this is Georgia. It is that close to the border. Here's what it looked like, the area looked like in the 1920s. You all have images of what the Appalachian Mountains are supposed to look like. Endless expanses of hardwood forests punctuated by cute little farms. This looks like it came out of Arizona and put in the end of the southern Appalachians. These are miners' houses. One of the things that made life for them particularly bleak is that they heated their households with fire, but there wasn't any wood. Most of these miners came from the mountains of North Carolina, Georgia, and Tennessee. They grew up in an environment where there were endless supplies of wood. Let's remember what the colonists used to say about the amount of forest in America then. The saying was that a squirrel could hop from tree to tree all the way from the Atlantic to the Mississippi and from the Gulf of Mexico to the Great Lakes without ever having to step to the ground. There was that much wood, and these people grew up in a place where they expected to have endless supplies of wood for whatever household purposes they needed. And instead, they lived in places like that, and they were literally going out and digging up stumps and buried roots to have something to burn, to heat their houses and cook their food. I found a darling memoir from a woman named Dorothy Galloway. She was a daughter of a miner, and many years and late in life, when she's 1990s, I believe it was, she wrote a book for her little grandchild and drew this picture. And the thing that she was trying to illustrate here was that she had these powerful memories of that being the only tree in Ducktown. This woman grew up in a mountaineer's cabin in the middle of the woods, and then spent her girlhood when her daddy moved to the mines. And remember, that is the only tree in Ducktown? I wish I could have gotten a permission from her to use that in my book, but she'd passed on with an unadministered estate. It's the only thing I hold against her. Here is a 1950 aerial photo taken by the state of Tennessee. I think we can dispense with the map. The picture speaks for itself. One thing you'll notice that because of all the erosion, siltation occurred heavily, made heavy deposits in all of the local stream beds. Nothing ran free and clear anymore. And all of that drained into the Ocoee system, which in turn drained into the Hiwassee and then into the Tennessee River. One of the other natural features of Ducktown that speaks to our story is the amount of rainfall, 60 inches of rain a year typically. With that amount of rain and with the topography being so sloped, any land that was left exposed by logging and by the effects of sulfur dioxide poisoning was left bare, and then it quickly eroded. To give you some scale, look at that telephone or telegraph pole there. In many places, they lost 16 feet of soil all washed down the river. And then by the 1950s, you end up with that. I think that's hydrogen sulfide that gives that horrible orange color. But the people were oddly, had a perverse pride in it. Everybody wants something different and unique about their community. And here, the folks in Ducktown lived in the only desert east of the Mississippi. The fact that it was man-made and the result of environmental pollution wasn't all that important. And in fact, when you go to the Ducktown Basin Museum, the guides there will happily talk about growing up there and how proud they were of the unique colors, the expanse of the sky, and the fact that there weren't any chiggers, snakes, or ticks, because there wasn't anything for the chiggers, ticks, and snakes to live on. So, short answer to the question, how did we get there? We had a century's worth of copper mining of high sulfur fuel, the production of sulfur dioxide gas, poisoning whatever grew there green, and there wasn't much of that left anyway because of the extensive logging. This was not a cut and run industry like so much of Appalachian resources is. Instead, copper mining began in the 1850s. It was shut down only for a few years during the Civil War, and it continued to 1878 until the exhaustion of the local fuel supplies with wood to cut down all the forest ended up shutting the industry down for 12 years. It revived in 1890 with the railroads, and then you had the two great players arriving, Tennessee Copper Company, a company that was headquartered in New York on Broadway, and the Ducktown Sulfur, Copper, and Iron Company, headquartered in London. Two foreign corporations domesticated in Tennessee, and that's where we can begin our story on the cases. So, first question, how did we get there? I've shown you. Second question, how did the case started by 10 humble mountaineers end up going to the Supreme Court? What I want to do as we go through this analysis is to argue that environmental law ought to be thought about in 4 different environments at least. One is obviously the substantive law. Second is the political. Third is technology. And the fourth, one should always remember the 4 things if you're going to say there's 4. I will come to it. But you've watched over the course of time how these different factors interplay, and that's what tells the story. It was never just a subject of substantive law. In fact, there were radical changes to the course of the law during the course of this case on up to this present day. So physical environment, political environment, legal environment, and technological environment. Told you I'd find it. So why did the cases start in 1890s instead of beforehand? It was a matter of scale. The industry, as bad as it was in terms of smoke in the 1850s and 60s, was a vastly smaller industry than it became in the 1890s when railroad technology, steam drills, and everything else that made modern mining easier to do ended up allowing the copper companies to process by geometric factors a greater amount of copper. And that meant with every ore process, 25% of that was sulfur dioxide, and it was burning off on those heaps I showed you and going into the atmosphere. How bad was the smoke? The farmers would complain they couldn't keep an edge on their tools because the smoke was precipitating as sulfuric acid and eating away the edge of their tools. Their crops were burning up. They could see it as an invisible force, the clouds of sulfur dioxide climbing up the water courses there, which was sad because the best Appalachian farming is always in the bottomlands. But sulfur dioxide is heavier than air, so it tends to sink, and it would travel right across the best farmlands. That was the process. And finally, some farmers got fed up and decided they would sue. Let's go through our analysis and think of what we can say about it. Political, what was the context? At the moment, not much. You had your farmers, humble folks, and the two great copper companies. There were no environmental agencies. That was half a century in the future, maybe more. There were no advocacy groups such as the Sierra Club. There was nobody. It was these folks going against the copper companies, and it was also going to be a crash course for the local attorneys to see if they could file a bulletproof nuisance case. And it took them a while to figure it out. What was the legal context? Total absence of environmental regime at all. In fact, let's make a caution about that. Though this is a key environmental case, nobody used that language. There was no reference in all this material to the environment or to ecology or to similar terms because the whole construct of ecological science had yet to be developed. The paradigm simply was not there. If you read this literature at this time, what they talked about was smoke. They talked about fumes. This was a smoke case. So we're just stuck with the law of nuisance, ancient aspect of the common law that we inherited from England. Theory is rooted on the maxim, sic uteri tuo ut alienum non laetus. That is the only Latin I know except for de minimis non curat lex, which has a rather nasty limerick going to it, but I'll leave that one alone. The whole idea of the law was captured in this maxim, so use your property as not to injure your neighbors. What's the interest protected? The use and enjoyment of property. It has nothing to do with a larger scheme of protecting natural resources or ecological communities. What's the standard of liability? Strict. And that was the problem for the copper companies. It was a matter of litigation in if-then terms. If a defendant's activity caused objectionable consequences, whether smoke, flood, stench, noise, or otherwise, that impaired a person's enjoyment of land, then the neighboring owner was entitled to recover damages or, in the alternative, to push for an injunction to abate the offensive activity. Even though the law stated at the Hornbook level was simple, there were enormous legal hurdles for the farmers involved. And the first one was jurisdiction. Remember, we're dealing at the junction of 3 different states, North Carolina, Tennessee, and Georgia. And we have 2 foreign corporations who are domesticated in Tennessee, but not in Georgia. This is the Stone Age when it comes to jurisdiction. There were no long-arm statutes. The minimum contacts test from International Shoe versus Washington, that was 40 years into the future. Diversity actions, they were possible, but these folks were poor. This was not a cash-rich society, so the idea of paying, first of all, meeting the jurisdictional requirement for the amount in controversy, and then traveling all the way to Chattanooga or Knoxville at a time when everyone traveled by horsepower, there wasn't a realistic option. So a Georgian suitor would have to resort to the Tennessee courts, and there they got beat up. And here's why. First of all, Tennessee had, in fact still has, 2 distinct court systems: courts of law for damages, courts of equity for injunction relief. Most states have combined both. But here in Tennessee, the first thing a litigant had to do was figure out what are you looking for and then make sure you filed it in the wrong court. And if you filed wrongly, the case would be dismissed and you'd have to refile or maybe get transferred. courts didn't meet very often in rural counties, so if you messed up the decision at one point, it could be 6 months or a year before you get another crack at it. Second thing, the copper companies did what corporations do, and that is to head off a case at the pass. The last thing a corporation wants to do, particularly on this kind of issue, is go to jury. Court in this area met in Benton, the county seat, which was in the Tennessee Valley side of things, and it was in the rural part, farming area of Polk County. It was highly likely that a jury would be drawn from other farmers, and whether or not they were farmers, they would be likely to pull for a farming litigant against the copper companies for the obvious reason that these are two foreign corporations which presumably had lots of money and could pay damages if you could get to the jury. So the copper companies did not want to get there, and they fended them off by pursuing a program they called keeping a blocked docket. They literally said that. I've got the correspondence from the corporate attorneys to their copper company managers. Their desire was to plug up the system, and they did it by getting a mastermind by the name of James G. Parks, who literally wrote the book on Tennessee civil procedure and had long experience as a judge. And he and his compatriots spent a decade thwarting these cases by every procedural maneuver they could find. We, again, start out thinking that cases are fought out on the substance, but here they spent almost a decade waging procedural battles before they got to the substance. What kind of stunts were they pulling? In this primitive area of civil procedure, you not only had to pick the right court for the right remedy, but if you were looking for wanting to sue the copper companies, you could not sue both of them in the same action. The procedure did not allow them to combine the defendants, as would be a matter of course if we did it today. And the copper companies knew that, so they filed to enjoin a whole raft of smoke suits and instantly took the number of smoke suits and doubled it because these folks had to refile again twice, once against Tennessee Copper and once against Ducktown Sulfur, Copper, and Iron. That was okay with them. Double the amount of lawsuits, we'll plug up the court system for sure. Even little things like the procedure of in forma pauperis, which allowed a poor litigant to file without fronting court costs. This was a big deal to mountaineer farmers. But the copper companies managed to get a law passed in the Tennessee legislature which prohibited that avenue for out-of-state litigants. So all the Georgia smoke suitors now had to front the cash. They could not even combine the petitioners or plaintiffs, because if they did so, that led to another injunction under the law of equity against collusive lawsuits. There was no class action mechanism then. So what do you end up with? Every farmer had to file by himself or herself against each copper company separately. And before you knew it, you ended up with over 200 smoke suits here, which again was just fine for the purposes of the copper companies. So how did Georgia get into the fray? The state of Georgia entered this case in 1903 and filed their first petition motion to the Supreme Court for permission to file an original jurisdiction action. What were they doing in this thing? First, as a political question, Georgia, as had been true of the neighboring states, had pursued a legislative policy for a half a century of promoting copper mining in the Ducktown Basin. Georgia had over 24 legislative acts to support one railroad or another to get them the funding so they could continue their work, and lamented the fact that the industry shut down temporarily in 1878. Why the change? Because now it was becoming a political issue. There were so many Georgian smoke suitors who had been beat up in the Tennessee courts. They were looking for another avenue to press their advantage, and they wanted to get the state of Georgia involved. From a politician's viewpoint, it was a low-cost decision. Why? The copper companies are on the Tennessee side of the border. Tennessee gets all the tax benefit, not Georgia. All Georgia got was the smoke. Second, Georgia was a stoutly pro-business New South state. Henry Grady made his name promoting business in the South. But they could go after these copper companies without upsetting the pro-business attitudes all over Georgia. In fact, Georgia courts were famously supportive of the whole industrial regime of Georgia, including the fact that all of industry was powered by coal smoke. So they could preserve the business climate in Georgia, but go after the Tennessee copper companies, and they could make a lot of mountain legislators happy. But there's another person promoting this. I think cases this big need a gadfly, and they had one in a fellow named Will Shippen. He was a descendant of the Philadelphia Shippens. One of them was a surgeon for George Washington. Another one married Benedict Arnold, so they worked both sides of the Revolutionary War. But these two Shippen brothers, Will and his brother Frank, went into the lumber business, and they logged substantial parts all over the country. And they literally surveyed all over America to figure out where they wanted to log next, and decided to start right here in Fannin County at the southern end of the Ducktown Basin. Why? There were railroads on both sides of the mountain. They could get their product to market. These were industrial loggers, and the interesting mentality went with a guy like Will Shippen, because on the one hand, he was a sophisticated businessman who was comfortable dealing with bankers and merchants in the major business cities of America, but at the same time, because his operations were in North Georgia, he was on intimate firsthand basis with all of these mountaineer farmers. He could work the political side, saying you need to do something about this, and then rally all the mountaineer farmers to put the weight of the action together. But Georgia had a lot of problems when they got into this suit. First, they had a weakness under the substantive law of nuisance. Fundamental to the law of nuisance is that you have to have a property interest to protect. But Georgia had distributed all of its land in North Georgia when they put it up for lottery after booting out the Cherokee Indians. So they didn't have public domain, and really scrambled to try to argue a colorable property interest up there, saying, well, we're kind of interested in the maintenance of the roads, and we're worried about the tax values of these properties and so forth. When it got to the Supreme Court, Justice Oliver Wendell Holmes said, that's all make weight. There wasn't anything to it. So that was their first problem, a substantive issue. And then on the procedural side of things, they had a huge problem. I call it the legacy of Chisholm v. Georgia. It amazed me how much fundamental constitutional law I had to wrestle through to get to this case. You remember the situation. Article 3 initially allowed citizens, state to sue citizens of another state and vice versa. And the case of Chisholm v. Georgia arose when a South Carolinian decided to sue the state of Georgia over some Revolutionary War debts. That led to the 11th Amendment, which changed the Constitution so that a citizen no longer had the right to sue another state. Well, here comes Georgia now wanting to jump into the smoke situation, but they were facing the problem that this could be considered a subterfuge. The Supreme Court was jealous of original jurisdiction. They didn't like to exercise it because they weren't set up to operate as a trial court. And they were especially sensitive to the idea that a state action that was colorable under Article 3 was in fact a subterfuge for private actions. And that was a powerful argument here, because by the time Georgia jumped in, there'd been almost a decade of private smoke suit litigation before the state ever got involved. Who was the state litigating for? Was it for its own interest? Well, it didn't have any public domain. Was it for the citizens? And if so, then they won't be able to access original jurisdiction in the Supreme Court. How did they get around that? They turned to an even deeper level of constitutional law, and that was the idea of invasion. You remember that this was at a time when there were thousands upon thousands of living Southerners who remembered the march of Sherman's army through the state of Georgia. And the idea was easy to sell, that smoke was an invasive force coming from a foreign state. Well, fundamental to the Constitution is that each sister state gives up its right to wage war against another state. If that's so, then the Constitution guarantees under Article 4 that the United States shall protect each of them against invasion. And that's how they argued this thing. The physical invasion, you could visual invasion of smoke up the mountain valleys, and using that as the constitutional basis to get into court. The other thing they needed was a scientific paradigm, because there really wasn't one, and it took them a while to stumble onto it. But here's where Will Shippen pops up again. Will Shippen, though he was an industrial logger, kept his ear to the ground, and he knew that at that time, in 1905, the federal government was pursuing a massive survey of forest resources in the southern Appalachian Mountains. That's a long, clunky title. I'll just call it the Wilson Report because that was the Secretary of Agriculture then. The premise behind it was that the nation was facing a timber drought. Remember, our squirrel is not going to be able to jump all the way from the Atlantic to the Mississippi because logging was at such a pace, people were now becoming afraid that they were going to log out all the virgin forest in America. It was a legitimate fear. It's a shameful thing where you take these enormous tulip poplars, trees with a 12-foot cross-section, and then grind them up into shavings for packing material. That was what you used before styro peanuts. That's what was happening to these forest giants. So the federal government had its own issues there too, as you know from your study of the Weeks Act. The federal government can instantly create a forest reserve on public domain out west because it was government land. They just set it aside. In the east, it was private property, and they struggled to find a constitutional rationale to spend federal money to buy private land to make a forest. How did they do it? Well, the stuff that happened 2 weeks ago was not the first time the Supreme Court's argued big stuff on the Commerce Clause. And they argue that they had the Commerce Clause here and the idea that the federal government had power over navigation, to control navigation of waters. The scientific underpinning behind all that came from a fellow named Marsh, who wrote the book Man and Nature in 1864. Well, now you can see my record taste. There's lots of bluegrass up there. Man and Nature in 1864. The argument was this. He was a guy that learned Icelandic. He was a linguist and a diplomat, went to the Mediterranean and noticed that all these areas that the classical writers said were forested were now barren. How did that happen? Well, they cut down enough trees and abused the land enough, and then the land loses its capacity to serve as a watershed. Without a watershed to receive and store water and to distribute it evenly throughout the year down to streams, instead the land is exposed to rapid flash floods, heavy erosion, and all the other consequences. And the argument was that all that was eventually going into the Tennessee River and would mess up navigation. That's how they got there. But that report, and more importantly, the fact that the federal government had a whole platoon of competent, highly trained life scientists, biologists, geologists, hydrologists, and most important of all, a fellow named Haywood, who was doing studies on SO2 pollution. Haywood set up an interesting experiment. Kind of looks like the phone booth in a Doctor Who show. And what he had was that phone booth. He put plants in there and gas them with sulfur dioxide and measure what it did to the plants by various concentrations. He was picking up on studies that the Germans had been doing earlier because they had their own issues in the Ruhr Valley of Germany. At any rate, now you have a scientific rationale to support the stream flow theory that was formulated by Marsh and the abundant documentation necessary to put it all together. So when Shippen sent a letter to the Attorney General of Georgia and said, I've been in touch with a guy from the Forest Service, you want to talk to him? The AG jumped on it and said, yes, I do. I will appreciate all the help I can get. And that's how they put the case together. I have here the final brief filed by the state of Georgia. No, this isn't the original copy, it's mine. But at any rate, this thing is 70 pages long, and I've already shown it to some of my colleagues over here. You know what's significant about that? There is only one case citation in the whole document. You guys have all written briefs, you know how to put them together. One case citation. And the reason that is so is because Georgia knew it had a weak case on substantive law, but they jumped on board with the Department of Agriculture and the Wilson Report and argued stream flow theory from beginning to end. And this is essentially a recitation of all the evidence gathered by the federal government through their field scientists to document the fact that SO2 is a terrible thing and it's going to exacerbate the problems of watershed preservation. That's how they did it. And they did such a good job that when Oliver Wendell Holmes made his decision, he said, turning to the facts of the matter, we can stipulate essentially that the damage there is massive and extreme. He gave 2 lines in the opinion to it. It was a given. He'd seen the pictures, and that was that. So he ends up turning the case and making a new legal rationale. Instead of being a decision where the state had to prove a property interest, he said it is a mistake to analyze this case through traditional common law nuisance. Instead, the state has an interest in the preservation of its own natural resources, in the quotation you've all seen and is cited endlessly. So the law gets transformed. A law that began as a private remedy ends up becoming a tool for natural resource preservation by state governments. And later on we see that happening here with the state of Massachusetts and sister states filing against the EPA on tailpipe emissions. That's how the state of Georgia did it. Let me wrap this up so I can get some questions in here. They searched for a remedy. Remember, technology was one of the environments I wanted to consider. The first goal of the state of Georgia was to end open heap roasting. You know, it was obvious the smoke was going straight into the air. And they got it into their heads that if we could just figure out a way to smelt this ore in an enclosed furnace, that would be somehow cleaner. Actually, it wasn't. They did figure out how to smelt it in a furnace, but the process ended up being vastly faster than the old method did, so they were processing more ore and the amount of smoke increased. Well, next round of technology, let's run it up a smokestack. So the Tennessee Copper Company builds a 325-foot smokestack that dominates the landscape. Trouble was, the mountains are higher than the smokestack, the sulfur dioxide stayed in the basin, and they just spread the impact further across the basin and added more smoke litigants. And then their last hope was sulfuric acid condensation. If they could capture the gas in the enclosed furnaces and then figure out how to process it in lead chamber facilities, they could then convert the sulfur dioxide into usable sulfuric acid. And this was actually a win-win situation. The South had millions of acres of worn-out cotton fields and had a crying need for fertilizer. They were shipping bird guano from the coast of Chile all the way around Cape Horn to try to fertilize cotton fields. But the South had also massive deposits of phosphate rock, but phosphate rock is not usable until it's processed by sulfuric acid. Then the plants could absorb it. So now we've got 2 companies that are producing sulfuric acid. We've got massive deposits of phosphate rock and worn out cotton fields, and they instantly sold every gallon of sulfuric acid they made. But we get another political player in here, the Farmers Union, National Farmers Union, which at that time was the biggest agrarian populist group, and it was headquartered in Georgia. You think, what do they care about Ducktown? They don't grow cotton up there. But the Farmers Union made fertilizer, and they were angry because all of the sulfuric acid for fertilizer was going to a northern fertilizer trust. Farmers Union wasn't getting any of it. And they had organized all through in every county in the state, and the farmers who already needed some political backing said, fine, we'll wave the NFU flag if you'll give us some lawyers. And the NFU lawyers were saying, fine, we'll jump in too, because by then Tennessee had made a big procedural mistake. They passed a new legislation to do away with champerty. Now lawyers could file contingent fee lawsuits for smoke. Woohoo. So you got mountain lawyers figuring they found the gravy train, filing contingent fee actions against a smoke company and the National Farmers Union back in the state of Georgia, and that's how it went on. But the search for the remedy was a key thing, because fundamental to Georgia's position is that they never wanted to shut the places down. From the very opening statement of Georgia's Attorney General in his annual report, he said, we do not want to shut down this company. I have a letter. This is the kind of stuff a lawyer shouldn't be doing with opposing parties, but it was there. It was a letter tendered by one of the copper companies straight to the Attorney General without going through counsel. And it said, you asked about the economic impact of the mines for Georgia. Well, here's the number of folks number of Georgians we employ in the mines. Here's the amount of purchasing we do from Georgian merchants. And it's all here, so if you need it, have at it. And that's what he used for political cover. Let's advance the story. The case ends up with a ruling in favor of Georgia in 1907. They have injunctive power. They didn't use it because they didn't want to actually shut down the mine, but eventually political pressures became too great. Tennessee Copper saw it coming. They decided to settle on very favorable terms. They said, we won't process any more smoke than we can, any more ore than we can handle, and we won't do it and we'll reduce production during the growing season. Remember, this is all about crops. And then the other company from London, maybe they had stiff necks in London, but they did not read the legal signals wisely and resisted the opportunity to settle on the same terms and decided to tough it out. It was a horrendous decision. And when the political pressures were high and Georgia needed to express that pressure by going after somebody, they couldn't go after the ones they settled with, so they went after the Englishmen. And the Englishmen lost in 1915 and suffered a quantitative injunction, said you cannot make but X amount of ore, process X amount of ore. The other side settled without a quantitative injunction. It just said, don't do this during the growing season. And then comes World War I. There's always other factors in substantive law, and here the war came. The United States entered in 1917, and all of a sudden sulfur and copper were war material. Bernard Baruch, a name you recognize, and Joseph Daniels, Secretary of the Navy, were both receptive to the lawyers for Ducktown Copper. They went to Washington and said, can you help us get rid of this injunction? We want to do this on the basis of patriotism and support of the war effort. And then Baruch and Daniels write the state of Georgia, and they frame it. It's no longer an issue about natural resources even. It's about patriotism and fighting the Germans. Always hunt for the paradigm. Where are we heading in the argument? And the paradigm changed yet again. It was now war. And under tremendous pressure, the state of Georgia relented and allowed Ducktown to settle on the same terms as Tennessee Copper. What do we do with this mess? By this time, Ducktown looked horrible. You saw the pictures. The state of Georgia bowed out. They pushed it as far as they could, and because the case had always been handled by elected officials, they simply ran out of institutional energy to push it any further. One of the biggest factors of having a bureaucratic regime for environmental law is that they have the staying power to see something through. I'm not saying they always do it, but they can. But there wasn't anybody to carry it on. But we get a new player coming in the terms of water power. That same Ocoee Gorge I showed you on the map, there's 3 power dams there. First one was built by TEPCO, Tennessee Electric Power Company. They had a beef of their own, and it was the fact that all that silt eroding off of Ducktown was going straight down the Ocoee River and doing horrible damage to the operations, the inside guts of the power plants. They had a crystal clear nuisance case. They filed it. They instantly won it. They got a big settlement, and that forced the copper companies for the first time to begin to think about reforestation. It got more clout that way when the federal government, a new player, comes in as the TVA. The founding law of the TVA includes soil conservation as one of its mandates. So they not only had interest in protecting their power machinery, but they had the soil conservation mandate and the whole weight of the federal government behind it. The copper companies quit fighting. They said, okay, tell us what to do, tell us how many trees to plant. And for the next 75 years, there was a cooperative effort between copper and TVA to try to revegetate the place. The trouble was the damage was so extensive that it took 75 years to figure out how to do it. And now if you go there, most of it is covered by some form of grass, or some form of kudzu, or really ugly pine trees instead of the old forest. But they had to revegetate. Next round comes in 1976. Those of you who've ever been down the Ocoee whitewater rafting, popular place. But it wasn't possible until 1976 because in 2 stretches of the river, the water was shunted out of the riverbed into flumes to run along the side of the mountain and then to fall down into the power dams. The idea was that if you could keep it level and get a dramatic drop, you would get more power. So there wasn't much water in the river. But they had to repair the second flume in 1976, and the water was flowing free for the first time in memory and instantly became a whitewater attraction at the time when environmental consciousness was rising. And then they eventually worked out a deal with the TVA. The TVA wanted to shut it off again, but now they have to have 120 days a year or so of whitewater in exchange for fees from the rafting companies. But then water, if you got water, whitewater people in the river, then water quality was all the more important, not just because of the new EPA laws, but because of the fact that this water was a sewer, industrial sewer. In fact, as late as 1996, when they did the Olympics on that river, it was biologically dead. They sent field scientists out there trying to find something living, but nothing did. And then to end the story, the EPA is there. They've worked out a voluntary agreement with the prime potential responsible party. The only one around is Occidental Petroleum, and it's under a voluntary agreement to avoid further sanctions. But to Oxy's credit, they're playing fair because they got badly burned in the Love Canal issue in the 1970s. So that's where we are. Many changes of the legal regime, changes of the environmental scientific regime, technological, and so forth. And that's how we get the Ducktown situation to where we are now. Questions? I've either bored you, I can't think I've overwhelmed you and cowed you by my intelligence because you're smarter than I am, or you got to go to your next class. I don't know.
I have a question for you.
Yes?
One of the things that I found interesting in the book was the discussion of some of the racial politics of the area and the time, and so I was wondering if you could speak to that a little bit.
The desired racial preferences in the Ducktown Basin were white only. There was a period when they were building a network of railroads to serve the mines. They brought in black contract labor, but the local mountaineer whites got their shotguns, I'm not kidding, and then they had a raid or two at nighttime and scared all the black labor away, and that's the way they like it. This was not a place that was devoted to the ideas of race, class, and gender. The mountain Appalachia had pretty strong whites-only emphasis to it, and all the miners, of course, were male. Some of the litigants were female because they were property owners holding dower interest and the like, but very close society.
I've got one. What do you think is the future for interstate air pollution nuisance actions brought by states, downwind states against upwind states? Do you think there's much future left in that, or do you think it's one of these things that's sort of fading away?
I hope it's not fading away. If we've learned nothing over the last 50 years of environmental law, we know that environmental impacts do not respect political boundaries. And that's the whole rationale for getting the federal government involved in the first place. So I think in addition to the quantitative efforts you have going by the EPA and their state counterparts setting regulatory standards, we had this discussion just an hour ago that there's still room for the law of nuisance. Nuisance measures impacts. Regulators tried to define, go to the other end of the analysis saying what's going to be entering into the atmosphere or into the waters, but nuisance measures impacts. And I think there's still room for that to maneuver. And you were telling me that that kind of litigation is now going on here in North Carolina?
Yes, there's been a number of efforts to look at use of nuisance and trespass to address groundwater contamination, drifting of odors across property lines and things like that when the regulatory regimes are insufficient to protect against those effects.
There was a recent comprehensive settlement between EPA, the state of North Carolina, and TVA over, and it arose from a series of actions, including some regulatory actions in the Clean Air Act. But then when those couldn't produce any results, the Attorney General's office went in a straight-out nuisance action against TVA in federal court in North Carolina and got some relief. Now that ended up being subsumed within a larger EPA when there was a change of administration. There was a change in attitude towards the litigation, and there's now a full-blown settlement between TVA, EPA, and the state of North Carolina where the EPA's come in on North Carolina's side. And that nuisance action, which was headed for a Supreme Court appeal, is now sort of moot because the settlement has taken care of it all.
Even then, what's different now compared to then is that the state has the resource of a sophisticated scientific bureaucracy to substantiate that. And if they were lacking there, they'd go to all three of the universities here in the triangle and get whatever resources they needed to bolster the case. Back then, when John C. Hart was Attorney General, this is how things were back then. Old ladies were sending him cuttings from their damaged tomato plants saying, you need to get this investigated. And then by this time, he'd had 10 years of this litigation. He was getting completely burnt out and said, perhaps it's just bugs. There was nobody there to hold him up. In fact, his attitude got so brittle, he eventually had to resign. He was becoming a political liability. The takeaway points here are this, besides the, oh, I'm sorry.
Sorry, can I ask a question?
Of course.
So I'm curious how you feel the dynamics have changed. If you see any analogies and differences between the relationship between environmentalists and coal miners today and the farmers and the ore industry back then.
Well, the same fundamental dynamic then is here now, and that is framed in simplistic terms, jobs versus the environment. There's a famous environmental history article written under the title, "Are you an environmentalist or do you work for a living?"
Which makes you think there might be more mutual respect for the farmers, though, than in today's environmentalists, I guess is what I was getting at.
Yes, but if you were a good advocate, depending on what side you were talking about, you'd be thinking, is this a farmer Joe and his 100 acres of family land that they've been farming since the days of Daniel Boone, or is this a corporate farmer who's got 20,000 hogs? That all depends on how you're looking at it. But what is different now is this. There is an environmental paradigm, and the public knows it. They may not always agree with it, and when you get to a point controversy between putting in a new coal-fired plant and all the jobs that go with it versus the environmental concerns, you know, it may be different there, but what you don't have to do is educate the public anymore on the fact that we have to have an environmental consciousness. Does it fade? Does it lapse? Is it under pressure? Of course, of course, of course. But it is there. After all, how many years has Turner Network been running Captain Planet? That wouldn't have been true back then. They had to argue it through forest conservation. But that leads to the takeaway points. Always be aware of the multiple facets on the case. It is never just substantive law. Watch for procedure. If you don't learn it on one side, if you guys flip over to working for corporate law firms, you sure will learn it. Second, beware of the moving state of technology, especially in nuisance law. State of the art is a defense. What can you do? Have we done as much as we can? Politics. All these things weave together and they are not static. You know, for all the advances we've had in this country when it comes to environmental advocacy and improving environmental health, if we ever had another war that required total mobilization of this country, there'd be a lot more logging in the national forest. There would be unlimited coal mining, and they'd have to be pushing away the caribou so they could get more oil out of Anwar. History always has a trump card. You might not be able to see where it's coming, but it's out there. And admiration to the sophistication of this department. I've been learning a lot about this. There wasn't any law department when I was here. That tells you something too, and now we have 7 or 8 faculty on it. Yep. And the conversations I've been having tell me that you are aware of these issues. Thank you so much for your attention. It was a very great privilege to come back here. And please don't call me a billy goat.
Produced by Duke University. Online at duke.edu.